Hello, everybody, and welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. And of course, this is part four for Bonnie Allen Thomas, or AKA Bonnie Straight. If you haven't watched parts one, two, and or three, um, I urge you to, after you watch this, to go back and watch those to give you a little context. But I'm going to do my best within this video to give you a little bit more context on Bonnie's way of thinking, how she decided, what her choices were. Let's put it that way. All right. And as always, we're going by the record. This is public records. Nothing I'm making up. Nothing, I'm just going straight to it. Oh, here. Let me, I was doing a little rearranging over here. And I unplugged my microphone. I believe we're hot now. Be really good, really hot. All right. Again, back here with Bonnie Straight. Of course, if you want to write Bonnie, here she is. I always mess that up, but it's kind of funny, huh? Anyway, Bonnie, if you want to write her, there she is. That's her TDTJ number. She's on the hobby unit right here. That's the address. Slide over here. There you go. If you want to write her? There you go. For those of you who have written her, hey, awesome. Hopefully she's written you back. Obviously, she hasn't written me. You can give her my address. She can write me P.O. Box 40635, Houston, Texas 77240. Fearless Floyd Show. Anyway, like, subscribe, share, hit the notification bell. That way, when I do put out new videos, you're going to get a notice. Hopefully, because YouTube does have a propensity to not make that happen. Yeah. All right. It's taken me a minute to kind of wind up to give you the completion of the whole Bonnie. This is Bonnie's story. Okay, that's why it doesn't say Bonnie Allen. She's had several last names, so I'll just stick to the facts. Bonnie Allen Thomas. I don't see Bonnie Allen Straight, right? So I don't know if they're really married because I keep getting emails from David's solicitor, whoever's in charge of his seminar advertising, marketing and advertising. And I get emails, and every weekend he's out there, doing the whatever David does to a audience, paid audience, while Bonnie over on the hobby unit, not taking it as a hobby. She is up for parole November 11th of this year. So if those of you who would like to support Bonnie, you can send support letters to the parole board, 8610 Shoal Creek Boulevard, Austin, Texas. And 787, I want to say 711, but I could be a little incorrect on that one. That was just off the top of my head, kids. But anyway, yeah. You can send all her letters for parole. And you can oppose, but generally you have to be a victim. Do we have any victims here? Anyway, let's move on. Let's get in with the video. Oh, by the way, if you don't know, Anne has a new book. She just put it out. Man, I don't even think I got it pulled up anywhere to even show you guys. I'm slipping. Oh, here we go. Here we go. All right. There's the PDF. Basically what the cover looks like. And it's roughly about 369 pages. This is probably a older edition before Ann and I really dug into it and got working on it and editing it. But this is basically what it looks like. So hey, there's my address right there. So if Bonnie wants to send me a letter, there you go. Boom. Anyway, that's what it looks like. We're waiting on our Library of Congress cataloging number. So as soon as I get that, that'll go on all the copies. But anyway, this book is available. Believe it or not, it's on eBay, it's on Shopify, it's on thefearlessfloydshow.com. It's on my website and then store. I'm trying to get it on Amazon. I got to master that process and getting it uploaded there. So yeah, this book was going to be everywhere. So if you haven't gone and visited the website, thefearlessfloydshow.com, you probably should. Um, I don't know why that took me to eBay, but it did. So I'll just show you guys that real quick while I'm there. Here it is. This is on eBay. This is for the soft cover book. The ebook is $249, and the reason I did that is because unless you tell me, I can't really tell what your purchase is if the soft cover and ebook are the same price. So, and especially when I was having some issues with my, and they're still working on it. Actually, I just got an email. I think they're going on their sixth day trying to fix it. So, yeah, way beyond my comprehension and control. So I'm just rolling with the punches here. But anyway, this is it on eBay. So you can go check that out. It's available there, as well as all the classes that we offer. And hey, breaking news, all of you out there who foreign trust, 9080 IM, foreign trust, guess what? It's here. Ann has already sent me the materials to review. So as soon as I get done with this video, I'm going to be reviewing them. And of course, today is Tuesday, 7-Eleven, baby. Roll those dice. Apparently, I did and lost. July 10th, 2001. Yeah, bad day for me. July 10th is just a bad day. More ways than one. Anyway, moving on. So we're gonna go over here and address Bonnie. So if you want the book, classes, hit my website, fearlessfloydshow.com. You're gonna reach me at fearlessfloydshow@yahoo.com. I'm the Fearless Floyd Show on probably every platform that you're gonna get onto or into or participate in or skim through or whatever. So I'm not hard to find, not hard to talk to. I am gentle on your mind, right? Okay, here we go. Y'all ready to dive into some Bonnie Allen Thomas? Before I begin, let me preface this that Bonnie, okay, looking at her public record, this woman has been in Texas state and federal district courts, U.S. district courts here in Texas multiple times. This woman is very well versed in the court system here in Texas, whether it's on the state or federal level. So she's got a lot of experience, likes to hire a lot of attorneys. So, like I said, I don't know too much about her background. I know what people told me, reached out and said, oh, hey, Bonnie this, Bonnie that, blah, blah, blah. I just go by the public record. That's all I'm doing. So that's what we're going to get into. I believe this is the one we want to read. Yeah, let me start right here. Okay. Of course, this is the opinion of the district court, U.S. District Court, Northern District, Texas, probably Fort Worth, Dallas, DFW. So it's Thomas versus State. So obviously she's suing a bunch of people. We'll get into that here in a second. Irma Carrillo Ramirez is the United States magistrate judge, not the U.S. district judge. So basically, the magistrates are the one who field all the cases. They're the gatekeeper. See who and what gets to the district judge, or if you have to appeal the magistrate's memorandum of opinion to the district judge. So all right, basically by special order, this pro se case has been automatically referred for full case management, including the determination of non-dispositive motions and issuance of findings of fact and recommendations on dispositive motions before the court are the following. By the way, Bonnie's the plaintiff. Okay, so here come the defendants. Defendant Danny Griffiths motion to dismiss the first amended complaint under Rule 12b-6, of course. And I'm not going to get into all that. Defendant Marc Pieroni motion to dismiss pursuant to 12b. I screwed up. 1 and 6. Rule 12b-6 works. Fair state claim for which relief may be granted by the court. Plaintiffs motion to disqualify opposing counsel for Marc Pieroni. So she's trying to take out his counsel. The 413th District Court Judge William Bosworth, 66th Judicial District Court Judge F.B. McGregor, the 18th District Court Judge John Neal, the 249th District Judge Dennis Wayne Bridewell, and the state of Texas's all conjoined motions to dismiss on the basis of official, qualified 11th Amendment and judicial immunity and absence of standing. Interesting. Like to read that, wouldn't we? That would be something to go dig into. That's why I like reading these, because you do find little gems in there. And I guarantee you, something put together by that consortium of legal horsepower. Yeah, I like to read it, because they're all putting their name on it, even with the state. So somebody of some intellect, I would hope, wrote that. So that's very interesting. That's document number 69. So if you want to go look at that, it's in this case filing. Go look it up. I can actually probably go get it because I have Pacer. All right. Defendants, Johnson County, Texas, Bob Alford, Ken Bartlett, Ronald McBroom, Dale Hanna, and Martin Strahan's motion to dismiss plaintiff's second amended complaint and brief in support thereof, and defendant Greg Gorman's third motion to dismiss pursuant to 12b-1 and 6. Court's findings. Based on the relevant filings and applicable law, the motions to dismiss should be granted. The plaintiff's remaining claim should be dismissed sua sponte for failure to state a claim, and our motion to disqualify should be denied as moot. All right, so there you go. That gives you a little context of who the hell who's in this. For those of you who don't know and haven't seen parts 1, 2, and 3, Marc Pieroni is Bonnie's, I don't know if they're divorced or not, but let's just say estranged husband, and they did not have a amicable separation. Let's put it that way. So it got ugly, and here we go. That's kind of the cause of the root of Bonnie's issues was from that case of their separation. So, all right. Background. Bonnie Allen Thomas, plaintiff, initially filed this civil rights action under Title 42 U.S.C. Section 1983 and 85. On February 6, 2017, she sues the state of Texas, Johnson County, Texas, former Sheriff Bob Alford, Deputy Sheriff Ken Bartlett, alleged confidential informant Daniel Wade Griffith, CI, the 413th District Judge William Bosworth, the 18th District Court Judge Neal, Municipal Court Judge McBroom, Johnson County District Attorney Dale Hanna, Assistant District Attorney Martin Strahan, 66th District Court Judge McGregor, 249th District Court Judge Bridewell, Marc Pieroni, his attorney Greg Gorman, and John Doe's 1 through 5 and Jane Doe's 1 through 5, collectively defendants. She claims that she, quote, has been the target of an ongoing conspiracy of county officials to persecute and oppress her and deny her justice in any court, county, on any matter, civil or criminal, close quote, in retaliation for a wrongful death action she and her siblings filed against county and sheriff, among others, in 2013. So let me, I don't even know if there's any background on that issue, what I just brought up, but let me address that from my own knowledge, not from the record. And what I was informed was that Bonnie's, and I could be wrong, this could be 100% inaccurate. So leave a comment below if you feel you can correct this, or if I've spoken incorrectly or whatever, and correct me. Or, you're not correcting me, you're correcting the material from the source that I received it. So I'm just trying to express to you guys so you have a little bit of context of where this is coming from. So apparently, what I was told is that Bonnie's father, this is all public record, I'm pretty sure what I was told, that her father passed away in Johnson County Jail. And I believe he was an alcoholic, probably had some health issues, which most elderly alcoholics do. And I don't know the circumstances. I don't know the story. I just know, a roundabout thing of what happened. She sued. Apparently, her and her siblings prevailed. And in doing so, they obtained a settlement. I don't know what that looks like. I don't know if that's monetary, a judgment, piece of paper. I don't know. So if you want to go look that up, that's what's up. So Bonnie, since that has occurred, has felt that she can't get any relief for any matter anywhere in Johnson County. So, you know, let's see, Bonnie, Fearless Floyd, in my humble opinion, it's my opinion. Don't take this as legal or financial or any kind of advice. I'm just saying it to say it. You probably should have left Johnson County as soon as you prevailed and hightailed it out and went you and got you some piece of property somewhere else and started over. But that's just in my opinion. So you stuck around and you've been, you already stole the bear's food. Now you're poking him with a stick. That's all I can say. So anyway, let's carry on here. So she filed this 1983, which is a civil. Excuse me, I'm on the air. Can you not read the sign? Oh, I forgot to teach my dog how to read. I'm on the air, baby. Okay. All right. So basically, she's just saying she can't get a remedy. Well, probably no surprise. So let's jump on to the first issue here. Because I want to get on, because when we get to the meat and potatoes of this whole thing, it's very there's a lot. So plaintiff and her ex-husband are the parents of three minor children, of whom she was initially awarded primary custody. Ex-husband filed a motion for sole custody of the three children, and in June of 2015 sought emergency relief based on allegations that plaintiff had confiscated their son's cell phone and, quote, was beating, unquote, close quote, him. Plaintiff claims that despite the responding police officer's conclusion that there had been no spanking, Judge Bridewell, quote, immediately removed all three children from her custody, close quote, and placed them with the ex-husband, quote, without proper notice and without opportunity to be heard, close quote. He also ordered drug tests, social studies, and psychological evaluations for both parents. At a subsequent hearing, Judge Bridewell refused to reverse his temporary order awarding custody to the uh, Judge Bridewell, quote, I'm going to stop quoting, okay? I'm just going to say quote and then read and you can figure it out. Quote, refused to reverse his temporary order awarding custody to ex-husband, whom plaintiff contends tested positive for drugs and is, quote, an active illegal drug user and has been investigated by CPS for choking their oldest son. Judge Bridewell denied her motion to transfer venue, but granted her request to recuse himself, and Judge Neal was then assigned to the case. This is where all these motions to recuse start coming from. Plaintiff sought an emergency hearing from Judge Neal, who refused to schedule one, and after discovering that he was out of town, she sought one from Judge Bosworth, who denied her request. Judge Neal held a hearing on August 28, 2015, after which he only modified the temporary child custody orders to allow plaintiff visitation. At a second hearing on September 2nd, 2015, roughly a week later, he allegedly verbally ordered the attorneys for the parties to file affidavits stating that their clients had turned over all firearms to their attorneys, but the order was never reduced to writing. Plaintiff turned over the only firearm she owned at the time to her attorney. Judge Neal also allegedly refused to schedule a hearing on plaintiff's, quote, writ of habeas corpus return of child under family code to dissolve the temporary orders granted without due process and return the children. Plaintiff also contends that defendants inflicted serious financial harm on her by forcing her into 8 hearings on Judge Bridewell's temporary orders between June and October of 2015. Criminal proceedings. Hang over here. Keep costs down and help her attorney. Plaintiff did extensive factual and legal research. See, I told you guys, she's no novice when it comes to the courts. Okay, she knows her way around. She's trying to do everything she can to help herself. On October 21st, 2015, and I want you to pay attention to what she's doing, okay? Because right now, she's doing everything textbook as normal people would do it through a judicial system, either civil, criminal, appellate, post-conviction, et cetera, et cetera. Okay. She's following the guidelines. She's basically adhering to, you can't see it with the background, but this is the Texas Code of Criminal Procedure. She's adhering to this, which also contains the Texas Rules of Evidence, the Texas Rules of Appellate Procedure, as well as parole laws. Wonder why it's in my possession, huh? So anyway, that's where that comes from. So, bam, she went to the on October 21st, 2015. She went to the Gwynn Justice Center in Cleburne, Texas, to do legal research. She, quote, forgot she had a small 22 caliber purse gun in her purse when she went through security. Security officers discovered the gun and she left to put it in her car. She was arrested while walking to her car and charged with carrying a gun in a prohibited area and evading arrest. Sheriff ordered her vehicle searched and impounded. Plaintiff claims Judge McBroom refused to set a bond for her, ostensibly because he was involved with other defendants to entrap her, and she was held under the control of sheriff and another wrongful death defendant. I guess that's omitted for some reason, that star 588. Wrongful death defendant in the same jail where her father had been confined. Contrary to a policy that detainees not be held in booking for more than 24 hours, she was kept in booking for 6 days and placed in solitary confinement and not allowed to shower for 4 days. I told you, if you win, leave. Get the hell out of Dodge. Go put your stake in somewhere else and make a claim. Okay. Don't stick around and try to poke these people in the eye every chance you get just for spite. Take the money and run. After a second bond hearing before Judge Neal, plaintiff's husband saw Assistant District Attorney Ada and attorney outside of the courtroom having an animated conversation about plaintiff. Attorney was trying to convince Ada that plaintiff was mentally unstable and should be denied bond. Plaintiff's attorney confronted attorney about his actions and they got into a heated argument. Ada argued that plaintiff should be held without bond until a psychological evaluation had been performed. One was ordered by Judge Neal, and he refused to set bond until it was completed. On her 10th day of confinement, Judge Neal set bond for plaintiff and required as a condition of bond that she be confined to her home and wear a GPS locator. He also ordered as a condition of her bond that she not have contact with her children. Judge Neal subsequently denied her writ of habeas corpus to amend bond conditions and remove the GPS locator. Plaintiff appealed the denial of her writ to the 10th Court of Appeals in Waco, and that court modified her bond conditions to remove the home confinement requirement. Well, good for her. She got a win. Mm-hmm. That's a pretty good court, actually. I believe I've got a couple of reversals from that court myself, but I did them myself. Judge McGregor presided over plaintiff's criminal trial for carrying a gun into a prohibited area. She alleges that Judge McGregor refused to grant her motions to transfer venue and motions in limine. Motions in limine are limine is Latin for to prevent from being entered into evidence or shown to the jury. That's what limine means. And that you okay, girly girl? When you over there playing with your bone, you got stabbed, didn't you? Oh no. Oh, I'm sorry. You gonna make it? Good. All right. Where was that? Okay. Judge McGregor presided over plaintiff's criminal trial for carrying a gun into prohibited area. She alleges Judge McGregor refused to grant her motions to transfer venue and motions in limine, and that he allowed prejudicial photographs to be taken of her. I don't understand what prejudicial photographs to be taken of her. I don't even know what that means. She claims that Judge McGregor allowed an unfair trial against her in order to secure a conviction. She describes one occasion during the trial in which Judge Neal was permitted to testify regarding the oral gun turnover order he issued in her child custody case, and she alleges he, quote, used his position and influence to secure a conviction for her. She also claims that Judge McGregor allowed testimony during the sentencing phase from deputy regarding an alleged entrapment scheme. What, you okay? Plaintiff hopes for appellate remedy, but such may be years of financial drain and physical and emotional drain. Well, that's a mouthful. So we're going to address your choices here in a little while, Bonnie. And we're going to see exactly how many years of financial, physical, and emotional drain you can withstand. What can I do for you, Dar? What can I do for you? You need to go potty? Ooh, somebody needs to go potty. All right, I'll tell you what. I'm going to pause this video right here. So let me stop share, and I'm going to pause, and I'll be right back. I'm going to take my dog outside. And I'm back, and the dog's happy. All right, let's get back over here on the screen. Carry on where we were. So we left off there with the financial, physical, and emotional drain. Here being foretold in I guess 2015. I don't know. We'll see here at the end. Uh, yeah. Wow. Foretold her own future. Plaintiff alleges that defendant's actions are all part of a conspiracy against her to deprive her justice in county, and that part of the conspiracy entailed entrapping her into agreeing to hire a hitman to murder ex-husband. She claims that her bond was denied during the criminal prosecution in order to hold her, quote, in solitary confinement to break down her mental functioning until a secretly wired audio and video confidential informant would approach her to try and convince her to authorize the murder of her ex-husband. This is public record, folks. Confidential informant, allegedly acting as an agent for other defendants, visited plaintiff on her third day in solitary confinement and asked her questions about the charges against her in an illegal custodial interrogation that provided valuable information about her defense. Confidential informant moved the conversation in the direction of a murder for hire scheme. Confidential informant stated that he had his own crew who would kill ex-husband and offered several options as to how he could kill ex-husband, including ways that it could be made to look like an accident. So I'm going to raise my hand here. yeah, me. Okay. Um, if she's in solitary confinement, how is she having an interaction with the confidential informant, who is obviously a male, because it stated he had his own crew who would kill ex-husband and offered several options as to how he could kill ex-husband, including ways that it could be made to look like an accident. Confidential informant allegedly informed her that ex-husband's murder would lead to the hassle-free return of her children. So I guess that's probably the citing of that case. And that she could pay him out of the money she recovered from ex-husband's life insurance policy. Oh, wow. What a scheme. She claims, I know, nobody's ever heard of this, huh? She claims that she would not take the bait and firmly declined to authorize confidential informant to murder ex-husband. Confidential informant allegedly handwrote a narrative report regarding his inside the jail attempt to entrap her, in which he stated that she enthusiastically assented to the murder for hire scheme. This just gets better and better, doesn't it? Told y'all, hang on. I know when you read these things, man, it's a trip. Confidential informant went with deputy to visit plaintiff at her home following her release on bond and allegedly tried to convince her to hire deputy, who confidential informant presented as a hitman to murder ex-husband. Deputy typed a narrative report regarding his third attempt to convince plaintiff to enter into a murder for hire scheme. She contends that the report, although written to do maximum damage to her reputation, admitted that she refused to authorize ex-husband's murder. Even though she refused the offer, 2 months later, her attorney informed her that she was being investigated for a murder for hire scheme. Plaintiff further asserts that defendants tried to bootstrap the entrapment scheme into her wrongful death in child custody cases. She describes 2 child custody hearings in front of Judge McGregor in which the 2 narrative reports and testimony regarding the alleged entrapment schemes were used to her disadvantage, resulting in orders for child support and supervised visitation against her. Yeah. Duh. Man. Um, I don't know what to say. Just look at her choices, her decisions. Okay. Is this somebody you want to associate with, follow, listen to their advice and follow that advice or their opinions or whatever they're pushing? Okay. So let's continue. Yeah. I haven't even got to David Straight yet. We're still on Bonnie. Wait till I get to David Straight. Plaintiff asserts claims under Section 1983 for violation of her constitutional rights under the First, Fourth, Fifth, Sixth, and 14th Amendment. She missed something. The Eighth. cruel and unusual punishment. Floyd, whip it out like that. And 14th Amendments to the United States Constitution under the 1985 for conspiracy to violate her rights, and under state law for invasion of privacy, defamation, libel, false imprisonment, and intentional infliction of emotional distress. Well, sounds like 8th Amendment to me. Cruel and unusual punishment. Uh-huh. You missed one. That's what you get for hiring an attorney. Just saying. She also seeks injunctive relief against the judges in their official capacity and the form of an order directing the state trial courts to transfer venue to a county in which the plaintiff can receive a fair trial in her civil and criminal cases, as well as compensatory and punitive damages against all defendants. Well, Bonnie, you were separated, you had custody of the children, and you had apparently a settlement, and you stuck around and pretty much threw sand in the face of everybody around you, and you expect to get some type of respect. Ain't gonna happen. So that's probably why you're on the hobby. Oh, wait till July. Yeah. You think this is good? Just wait. Okay. All defendants have moved to dismiss all claims against them under Rule 12b(1) for lack of subject matter jurisdiction. What? Lack of subject matter jurisdiction, and or Rule 12b(6) for failure to state a claim which relief may be granted by the court. The motions are now ripe for determination, and they're all granted. And I'm surprised they haven't come at her yet for vexatious litigant. But when I get done with this video, you'll probably like, oh, well, yeah, she's probably on the fast train there. Okay. All defendants except confidential informant move for dismissal under Rule 12b(1) and, of course, 12b(6). And basically, they're just breaking down what the rules are under these, failure state of claim and subject matter jurisdiction, blah, blah, blah. Most of you know all this. If you don't, you can go read this yourself. Here's your 11th Amendment immunity that they're addressing, the state level. Boom, boom, boom. Judges in their official capacities, how they act. Younger abstention doctrine. Defendants move to dismiss for lack of subject matter based on younger. Federal courts must refrain from considering requests for injunctive relief based on constitutional challenges to state criminal proceedings pending at the time the federal action. Oh, yeah. Ongoing state judicial proceeding. We already know that. Important state interest. Yeah, here we go. Child custody. Interest of the children. Opportunity to raise constitutional challenges. Bad faith exception. C. Brooker Feldman. So you have all these people just, throwing, curveballs, fastballs, changeup, knuckleballs, sliders, underhand lobs. So they combined all this, and that's what they're doing. That's why it's all over the place like that. There's your 12b(6) stuff. So this is an excellent read if you want to read what they use to beat up a claim under Rule 12b(6). Okay. Oh, here it is, straight from the court. So, absolute immunity, judges and prosecutors move to dismiss all claims based on absolute immunity. Here's judicial immunity. What that is Judge Broadwell, Judge McBroom, Judge McGregor, Judge McNeil, each one addressing all this stuff. Bosworth breaks down who they were, blah, blah, blah. Witness immunity. He came in there and all he testified was, hey, I gave her this oral order in court to do this, and Apparently she signed an affidavit saying she did that, and boom, here she pops up with another weapon, another firearm. So that's all he testified about. All right. No, or just the description of the courthouse. Y'all remember that one? Okay. Prosecutorial immunity. Dismissed because they're absolutely immune from liability arising from decisions made and conduct taken during the prosecutorial process. That would be prosecutorial misconduct. It's a whole different thing. Section 1983, qualified immunity. Municipal liability, we can go on. Conspiracy, agreement, constitutional violation. I mean, this just breaks it down, but this is just putting all the state law claims, election remedies, Tort Claims Act. That was Texas Tort Claims Act. Intentional infliction of emotional distress. They're going to beat all this up. Invasion of privacy, defamation, and libel. Well, they're addressing everything. So spontaneous dismissal, opportunity to amend, recommendation. Okay, boom, 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 boom. As we read up there, citations to the record. The lawsuit in which here we go. The lawsuit which arose from the death of her 69-year-old father while he was incarcerated in the county jail in 2011 was settled in 2016. See Alan Pieroni et al. Versus Southwestern Correctional LLC, which is a private prison corporation, obviously. Although plaintiff does not specifically allege violations of her Fifth Amendment rights, her Second Amended complaint repeatedly invokes that amendment. Because this is what happens: you get in there, in the RIT room in jail, and everybody's giving you all this advice. You start throwing everything up against the wall, see what sticks, and we're going to see that get repeated with a different avenue. After defendants moved to dismiss First Amendment complaint, this just goes more. It's just they're breaking it down. What the reason this is so lengthy like this is they are addressing this because they don't like this. Same thing Chris Hauser did. When they came back, slapped Chris Hauser. The same thing. They're making an example. Don't come in here with that BS because this is what we're going to do. All right. So that's the end of that. So she did not prevail. Ooh, there's something there at the very tail end of that. Okay. This section 552 point, I think 226. Yeah, I got to read that. That's nuts. Anyway, all right. Let me go set up the next template for Bonnie. I believe it's not that one. Oh yeah, there we go. Oh, it does. That one. So, yeah. All right. Yeah, I guess it. Let me share my screen. All right. Like I did in the other videos, basically, I went to the Johnson County District Clerk's office. I did a search for Bonnie Straight. It's great. Last first name Bonnie. See, so right there, that's why it popped up. Append it. So Bonnie Allen Thomas, also known as Bonnie Allen Pieroni, or Bonnie Ruth Allen Pieroni. Like I told you, she's had a lot of last names. So, yeah. And here's her carrying a weapon in a prohibited place. All right. And we went through this in the other videos. I'm going to enlarge this for you guys, for all the ones who have deteriorating vision, such as me and myself. All right. So here we go. Carrying weapon prohibited place. She pleads not guilty. Disposition. She was convicted. She was sentenced to 5 years probation. Amended plea not true. Amended disposition probation revocation on May 5th, 2023. So here we go. So she was on probation for 5 years, 2017. Okay. 5 years from March 30th is March 30th, 2023. So what happened between March 30th, 2023 and May 5th, 2023? That it's a month gap, basically, about 6 weeks, almost 5.5. What happened in that 5.5 week gap when she should have discharged her probation? She should have been off paper, as we call it, and discharged that flat and walked away and been off. But how do they come back? Okay, this is a this is a legal question. It's on the table. What happened? She should have been off. You should see 0530, or I'm sorry, 330 2030 2023. Yeah, March 30th, 2023, discharged. Okay. But instead, we see she gets picked up on these crazy charges. So apparently, they revoked her probation same day, amended the sentence, and they sent her to prison. Judge ordered confinement to commence May 5th, 2023. 5 years, Texas Department of Criminal Justice. She got jail credit of 38 days. So that's what it's saying right here. All right. So we're going to continue on down here. So as you see, all this started again on October, what was it, 23rd of 2015? And we've gone through all of this, indictment, boom, 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 2016. This is where they're going back and forth. Okay, all these motions to withdraw counsel, letter of representation. Okay, we're still in 2016. There's a lot going on here. Don't. There's that motion in limine. Okay, motion to suppress. And this just went on in 2017, which is when the trial was held. Another motion for limine. Jury trial held, order petition for writ of mandamus, writ of prohibition, request for emergency relief, letter from the 10th Court of Appeals, memorandum of opinion, judgment, subpoena, another subpoena list, some more motions, jury trial held, jury trial. Here we go. Jury trial right here, convicted on March 29th, 2017. Note from the jury, charged to court, judgment, jury trial, convicted, payment plan, charge sheet, extension payment agreement, copy to probation, felony community supervision order, evidence inventory form, trial court certification, defendant's right to appeal, docket entry, felony community supervision order, letter from Brenda Chavaria requesting Bonnie Thomas use of the law library, denied by Judge Bosworth. Bonnie's notice of appeal, letter from the 10th Court of Appeals, notice of appeal filed, notice of appeal, letter from Attorney Niles Illick, requesting the transcript in order to do the appellate brief. Standard motion for new trial. It's going to be denied or let lapse by operation of law after 120 days. It's just a ministerial function. It's not mandatory. Bond conditions, appeal bond conditions, because she had under 10 years or under. So she's eligible for a bond if she is incarcerated. Bond conditions, motion for bond conditions, order proposed order for setting, motion, proposed order, letter from the court, bond hearing, bond report of violation, information, agreed order, boom, 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 boom. So whatever is going on around here looks like she's struggling. And this is my own opinion, my own experiences. Yes, I've been on probation and parole at the same time. All right. Memorandum of opinion from the 10th Court of Appeals. Motion denied. That's probably the mandamus. Okay, because they consider writs of mandamus as a motion. Court issues a mandate in 2020. Motion for continuance order. Okay, here we go. Y'all ready? Right here. States motion to proceed with implementation of punishment and impose certain specific terms and conditions of something. Docket entry, cancellation of all prior powers of attorney. Okay, so I want you to look at the date. Okay, this is 7/14 right here. That's the mandate. Okay, when the mandate comes, that's a wrap. That's a fork. That's done. Okay, that's a final judgment. That's what that means. So 2020, she got a final judgment. There's the mandate. So I don't know who this letter motion continuance is. I would imagine it would be her, because it looks like the state filed a motion to proceed with implementation of punishment. So they want to move on, get this thing out of the way. But here on July 27th, all bets are off. Cards are on the table. The rules have changed. The players have come and gone, and it's a new ball game, folks. And this is what happens when you listen to David Lester Straight. And we're going to walk through this. And once I start walking through this, you're like, oh, yeah, okay. Yeah, I recognize all that. Yeah. Wow. You can see it. You can see the difference. So I'm going to point it out to you, and you're going to see the demarcation between what she had been doing in the past with her either retained or court-appointed counsels, and then all of a sudden, boom, the whole legal vehicles being submitted, titles have changed, and when you read them, hear them, you're going to recognize them. They're like, okay, there we go. Choices, Bonnie. You're in a perfect position to focus on yourself and focus on your future. Evolve. That's all I can say. All right, let me carry on here. So as you can see, a lot happened here in July. Okay, that kind of was the culmination of everything, except it wasn't. So on the 27th, boom, we get this cancellation of all prior powers of attorney. order regarding defendant's request for continuance, order for continuance, order regarding defendant's request for continuance, motion to withdraw as counsel, motion of Emil Lippe Jr. and Lip Associates to withdraw as counsel for defendant. Okay, on the 28th, I told you the whole dynamics of this changed. Bam, that last week of July in 2020. I wonder who stepped into Bonnie's life at that time. If you're out there, leave a comment below. Tell us all your own experience, your own knowledge. July 2020. Where was Bonnie? Where was David? Did they commingle, intermingle? Did they meet prior to that? What is it? Tell us. Leave a comment below. I'm eager to hear it myself. All right. So let's see. Notice of judicial clemency for defendant placed on probation. Felony community supervision order, Exhibit A, order granting motion for withdrawal of counsel, emailed, docket entry, Bonnie Allen Thomas, affidavit of truth, letter setting hearing, notice issued to Bonnie Allen Thomas, notice Thomas, Bonnie Allen. No, listen carefully, please. Then, August, the last week of August, hearing held, notice returned Bonnie Allen Thomas unexecuted, another affidavit of truth, notice returned Bonnie Allen Thomas executed, letter from defendant, notice of appeal. Okay, so I don't know what she's appealing. Then 4 days later, notice, mandatory notice, Foreign Sovereign Immunities Act. Notice, active expatriation and oath of allegiance. Notice, acknowledgement, acceptance, and deed of reconveyance. Docket entry. Notice of appeal issued to 10th Court of Appeals via whatever. Another letter transferred to the 7th Court of Appeals. Then on August 31st, a letter from the 7th Court of Appeals. Appeal has been transferred from the 10th Court of Appeals to the 7th Court of Appeals. On September 15th, notice of default and second opportunity to cure and the maxims of law. That was September 15th. September 28th, request for extension, have not received designation request from defendant. Docket sheet entry, request for extension sent to the 7th Court of Appeals. Letter of designation sent to Bonnie Thomas via mail, along with a copy of request for extension to the 7th COA. Let's see, October 8th, 2020. Almost 5 years after her little run-in at the courthouse. Letter from the 7th Court of Appeals regards on November 3rd, they issue a judgment and an opinion, memorandum of opinion, so they stuck a fork in her. On January 28th, 2021, notice of default and third opportunity to cure and contest. What are we hearing? We're hearing the administrative. Yes, you're the private administrative procedure. It's exactly what you're looking at. All right, so here we go. Next day, we get a letter from 7th COA. The mandate is issued, so stick a fork in it. That's a final judgment. On March 30th, 2021, 6 years later, state's motion to transfer jurisdiction put in court box, order put in court box, proposed order, order setting hearing, notice, state's notice of non-compliance. That was the next day. April 12th, canceled motion hearing. April 23rd, non-negotiable notice of acceptance. I'm going to say precinct 1. The same thing, a non-negotiable notice of acceptance. Same day, notice of and rescission of dishonoring and defacing order for cause. 3 days later, on the 26th of April, non-negotiable notice of acceptance. Notice of and repentance of sins for cause. notice of rescission of dishonoring and defacing order. And then on the 29th, an order denying state's motion to transfer jurisdiction emailed on May 10th, my sober day, my sober birthday, the real one. Notice of dishonor. This is all from Bonnie. Another notice of dishonor. Third notice of dishonor. On May 24th, notice of and rescission of dishonoring and defacing order for cause. Notice again, same thing, on June 7th, about 2 weeks later. Notice of dishonor, Johnson and Somervell Counties Community Supervision and Corrections Department. Bob Somervell County's Community Supervision and Corrections Department. Caitlin Marsh, 1 original, 3 copies. On May 2nd, wow, 11 months later, May 2nd, 2022. Okay, now we've gone through COVID. All right, so we're just coming up off COVID over here. Court to defendant, letter from court to defendant, letter from defendant, letter from defendant. June 21st, letter to defendant, demand to discharge debts and demand for relief from ongoing injuries, notice of claim to property. On September 30th, 2022, a warrant issued. September 30th, 2022, motion to revoke probation. And a capias was issued capias. That means any law enforcement officer in state of Texas or even a bounty hunter can go get her. Here's the capias. It was recalled, returned unserved on January 25th, 2023. So that was what, 4 months later? It was returned. So back to September 2022. We're going to move into October 3rd, 2022, almost 7 years after the offense at the courthouse. Order issuing capias. And I'm showing you how lengthy these processes can go because, now she's got another 5 years. She got a 5-year sentence on probation, almost did it, and then has been fighting these last 2 or 3 years. And now she's got to go back and do 5 more on paper. If she can do it all in one shot, in and out, all 5 years without violations or new offenses or poking somebody else in the eye or association with questionable characters. Just saying. She's doing that original little 5-year probation that she got on the layaway plan. And you see how it's affecting her future. Like she predicted. The drain, you're looking at it. So, following David Lester Strait, we will continue. And we're going to see where that leads. Oh, prison. His ace coon boom. His boo. His girl. His wife. His companion. His lover. His co-host. Well, I don't know what to tell you about that. My sponsor hit me up. All right, so we're over here in October of last year, 2022. Order issuing capias, order of assignment by the presiding judge. So that's the administrative regional judge doing an assignment for somebody. First amended motion to revoke community supervision. Information to jailer. This is all January 5th. That's when the motion to revoke is. Information to jailer. Warrant recalled. Warrant issued. Warrant returned. Capias recall. That was all January 5th through the 25th. And then on April 10th, warrant was served. On April 13th, second amended motion to revoke community supervision, no service. On April 17th, 2023, and this is roughly 2.5 weeks before she was strangle-held in Johnson County, Cleburne, Texas. All right, so here we go. Warrant served on the 10th of April, April 13th, second amended motion to revoke community supervision. On the 17th, motion for leave to execute private trust. Exhibits. Filing party, David Lester Straight. Okay, well, get back on that. Oh no, Mr. Bill Straight. Bonnie Straight. Search. And it's over here. That one. Open back up. What happened? There we go. I'm about to blow this back up for you guys. See. All right. Now I'm going to stop share and share again just to make sure that Sharon's sharing, because Sharon likes to share what she has to share. Just sharing. All right. As you can see, we are scrolling back through the 2017s, 2018s, and 2019s. And that was quick because there was no 2018 there to be had. So moving on. And we're going to jump right up over here to the present day. A couple months ago. Where are we at there? 2020, 2021. Notice of dishonor. Oh, yeah. Let's get back to that whole David Lester Straight. Yeah, I want to see that again. In black and white, man. There it is. There he is. There he be. David Lester Straight. Filing party. It was a party. It's a party. All right. Motion for leave. Slide that back over. Shrink it just a hair. I want David's name in there. Bright lights. Got to give credit where credit's due. Ain't that my motto? All right, here we go, kids. I'm sorry, folks. Motion for leave to execute private trust. All right, motion. So I'm asking you a favor, and I need your permission to execute private trust. All right. The next day, there was a hearing. It was held. Verifying defendant's receipt of second amended motion to revoke community supervision. So that was just a revocation hearing, basically. And then on the 19th, the next day, so there's a lot happening here in this mid-April, a lot happening in April, period. Okay, on the 19th, other declination of appointment as attorney Dan Bonner. Appointment of attorney on 4/20. Warrant return. Motion to revoke is executed. Oh, sad day. Probably should have put that in your pipe and smoked it. 4/21. Order setting hearing. Copy to probation. Emailed to attorney, jail, DA. Motion to revoke. First amended. Other declaration of equitable. Okay. Defendant's motion or defendant's declaration of equitable protection under God's immutable law sent to court, document file marked, and doesn't have a filer on there. So 3 days later, on 4/24 of 2023, motion for release from bodily confinement. Proposed order sent to the court via Q. Motion to seal for the purpose of leave to execute the private trust. Motion for expedited hearing, leave to execute. Motion for expedited hearing, leave to execute. Permission to execute. Expedited hearing. Okay. Subpoena issued to Deputy Sheriff David Bonner on the 25th, the next day. Again, subpoena David Bonner unserved. Subpoena request. Then the next day on the 26th, email correspondence from Judge McGregor. Then on the 28th, 2 days later, research request, certified copies, research response, place certified copies in box. Okay, here we go. May 4th, 2023, docket entry, letter to D. Lloyd, order, promissory note brought in by David Strait. Promissory note, order. May 5th, 2023, motion to revoke. Result held. May 5th, docket entry, challenge of standing. May 5th, docket entry, notice of waiver of judicial immunity, notice of violation of Foreign Agent Restriction Act, notice of violation of fraud, notice of personal violations, walked to court. Receipt for certified copy of docket entry. Docket entry, writ of mandamus. I don't know who filed that. I would imagine it would be her or David, one or the other. Information to jailer, state's second amended motion to revoke, amended in court. Trial court certification, defendant's right to appeal, defendant refused to sign. Docket entry, admonishment to defendant on motion to revoke or motion to proceed to final adjudication, judgment, bill of cost, commitment, notice of appeal, attorney pay sheet, docket entry, docket sheet. That's it, all on May 5th. And then 3 days later, on May 8th, 2023, notice of appeal submitted to the 10th Court of Appeals, which actually is supposed to go to clerk, but whatever. The district court. Receipt, copies of documents for case numbers, these 3 cases, and I don't know why they have these 3 different case numbers. It's so crazy. On the 9th, we have a letter to the 10th Court of Appeals. On the 9th, designation letter sent to the court, sent to Bonnie Thomas in jail. Other case summary sheet. And then on May 15th, we have judgment nunc pro tunc. Where have we heard that from? On the 16th, we have a receipt, copy of judgment nunc pro tunc paid by Lydia in cash. And then judgment nunc pro tunc, second nunc pro tunc on the 24th. And then on the 25th of May, letter from defendant, attached notice of rescission. And then on May 25th as well, notice of rescission mailed copy to defendant. So they file stamped it and sent it back. So let's see what else we got here. Financial information. There we go. Total payments and credits, balance due as of financial information. Damn. She owed $10,807. I don't even know what that's for. Assessed on August 8th, 2017. Man, that girl paid $10,229 one spot. How? What's wrong? Yep. Oh, on April 18th, 2023. Hey, folks, look, this is how much she owed, $10,807. Okay, as of 8/8/2017. Okay, here's a payment on 8/8/2017 of a whopping $2. She paid $2. Make you holla for $2. And then here's another payment, $60. Oh, big spender. All right. Then all of a sudden, she jumps from, I see these transaction assessments, but I don't know what the hell those mean. All I see is payment. That's what I'm looking for. I'm looking for the facts. What's the facts, man? So anyway, so Monday, July 3rd, somebody made a payment right here of $450. But what I want you to see is in April of 2023, what have Bonnie and David been doing for the last year? They've been hitting it hard every weekend. And look, there you go. Man, they went and paid this off. And I don't know what this is for. And I don't understand. Because in Texas, you don't pay your court costs and fines and fees unless that's something to do with probation or something else. I don't know what it is. I have no idea. Bonnie, tell us. Somebody else, anybody, if you know, leave a comment below. Tell us what it is. I'm curious to know, just like everybody else. So now you see kids in black and white. What happens when you listen to David Lester Straight? Okay. What happens when you listen to David Lester Straight? That happens. You get mug shots and you go to places like that. You know, they used to call them state farms here in Texas because the majority of the old historical, what we call red brick prison units that were built in, all the way back to 1845. Yeah, 1845. Most of them were built in the 1880s and in the 1930s. If you do your history, the next big explosion was in the 60s, a little bit in the 70s, and then of course the 80s. We had the big boom, 80s and 90s, and then here we are today in Texas with over 100 separate prison units in the umbrella of the Texas Department of Criminal Justice. Yes, just a little FYI there. Share my knowledge. Like I told you guys, there's a book on Texas prisons. I've read it, and I probably have met a dozen of the people that are spoken of in that book. Absolutely. Told you I had a charmed life, man. I, really met some interesting people in my life from all walks of life, billionaires all the way down to serial killers. Who can say that? Where have I go? Oh yeah, hey, if you like the video, like. You like my channel, like what I talk about, you like my, like whatever, anything. You like a little bow, wherever it is. You like that. You like my polo. Hit that like button. You want to get notified? Maybe by YouTube when I put out a new video. Hit that notification bell. Subscribe to my channel. Leave a comment below if you want to reach me. Fearless Floyd Show at yahoo.com. Go to my website, thefearlessfloydshow.com. Keep up with the latest scams and scam artists, and go get some product, go get some classes, check out Ann's new book. We're also got 501 class, 98 foreign trust coming at you. Boom, 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 boom. Again, thank you, Ann LaFleur, for coming through, pulling all punches. It's a knockout in Texas. Y'all be sure and send Miss Bonnie a nice little letter telling her that you want to support her, tell her to focus on herself, do a little introspection, and evolve. Hopefully she can learn her lesson and make some better, wise decisions. Hopefully. All right, kids, I think sorry. Okay, folks, I think I've covered everything with the whole Bonnie straight, David Lesser straight, what you should listen to, what you shouldn't listen to, what you should do, what you shouldn't do. Take it for what you want. That's the public record. I just present the evidence. You do with it whatever you like, form your own opinions. I don't matter in this whole thing. It's the public record. This is all about Bonnie, not about me. It's not even about David, but you can see where she started this venture in October 17th of 2015. 2015, October of 2015. Okay. She did almost all 5 years on probation. There's some gap in there, and now she's got to go do another 5. So that's like a 13-year sentence. That one initial charge. And now is she going to make it even worse? Because I wonder if they have her in administrative segregation in prison because of David Lester's. That would not be surprising to me one iota. Absolutely. So she may be punished just for, association, character association, kind of like character assassination. All right, folks, thank you very much for being here. Again, I am Fearless Floyd. Go get Ann's new book, 369 pages, How to Create and Operate a Revocable and or irrevocable trust. Everything's in there. The instructions, templates, examples, everything for walk you through A to Z for all of that, how to operate in trust, get your bank account, EIN, all of it. It's there. God bless her. The book is available almost everywhere. I'm working on that. So you should be able just to plug it in and Google search, and it should pop up in some platform here eventually. Soft cover books, they're coming. I'm waiting on the Library of Congress to send me my information. Once I get that, then I can send everything to the publisher and start getting those cranked out. Until then, we have the digital copies available if you'd like those. So just hit the. Again, thank you for being here. I hope you enjoyed this series on Bonnie and not Clyde. And Bonnie, look, sister, you're an offender now. And it's an app picture. I'm sure your other one in PDCJ doesn't look much better. But anyway, thank you, kids. I appreciate you being here. Like I said, without you, I'm just sitting in my formal dining room talking to my laptop. So I do it anyway. Might as well have some fun with you, right? I'm out.